Good day, Crime Talk aficionados. We have a huge show for you to take into the weekend. First, Bryan Kohberger doesn't just get shut down and denied. The judge mocks their argument. We've got the closing argument summary from the defense in the Sean Combs matter. A tenant from hell. Okay, wait for it. Another teacher arrested. And for you know what. Big day at the United States Supreme Court. A quick summary of this term's major opinions. This day in legal history, our quote of the day has to deal with the United States Supreme Court and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, go check us out on any of your favorite podcasting apps. Now, before we get to the docket, let me remind you to go to crimetalksearch.com, where you can sign up for a background subscription service today. All right, go there, sign up, and you can do as many background searches on anyone here in the United States that you desire. 1 person, 1,000 people, 5,000. Anyway, the report is completed while you wait, and it is emailed to you. And you're going to get more information than you probably would ever find out about this particular person. You're going to find out phone numbers, email addresses, social media presence, legal documents related to property that they own or that they've sold. Are they married? Are they divorced? Or do they have a criminal history? Go there, crimetalksearch.com. Find out what somebody may not be telling you. All right? You're going to be happy that you did. All right, let's go ahead and get to the docket because we have a big docket for you today because there were some major rulings that came out yesterday evening. They were posted on the court website as it relates to the Bryan Kohberger matter. And let's just say Bryan Kohberger has been dealt a huge blow to his defense after an Idaho judge slapped down his efforts to point the finger at 4 alternate suspects, blasting his legal team's evidence as entirely irrelevant and wild speculation. So in a scathing order handed down Thursday afternoon, Judge Stephen Hippler blocked the accused mass killer's defense from presenting evidence to the jury at his capital murder trial, alleging that these mystery individuals and not Bryan Kohberger could in fact be the real killers. Anyway, this marks, like I said, a major defeat for the Kohberger defense strategy in a case where the prosecutors are obviously seeking the death penalty for the brutal murders of Xana Kernodle, Etha Chapin, Kaylee Gonzalez, and Madison Mogan. In the order, Judge Hippler hammered the defense, saying that the evidence presented to the court was entirely irrelevant and that the attorneys had not shown a scintilla of competent evidence connecting the 4 alleged alternate suspects to the crime. Now, I could leave it right there. Could I not? But why would I do that, ladies and gentlemen? Because we want you to have all of the information. So whether you're obviously rooting for the prosecution, and many people are, you understandably, there was a horrendous quadruple murder that took place, and people want to see justice is done. Then you got a lot of people on the Kohberger argument that think that he is being railroaded in some particular way. But the reality of it is you need to understand the court's complete order. I can simply say, well, the judge denied the motions and it was kind of embarrassing. But you need to know the context as to what the defendant was arguing and the evidence that was raised. At least we find out a little bit more about it. So, as we've done in the past, let's do it. And if you don't want to listen to it, you can fast forward to the next topic as it relates to Sean Combs. But let's do this. We got the redacted order on the defendant's offer of proof regarding alternate perpetrators. Now, this order has a couple of redactions, so obviously I don't know what's in there, but I'm sure we'll be able to read between the lines a little bit, but more than likely hides the names of the individuals that the defense was trying to accuse of a quadruple murder. So let's get to it. Introduction. The state previously moved in limine, seeking to preclude defendant from offering or arguing alternate perpetrator evidence without first satisfying the applicable evidentiary standards. In accordance with the court's subsequent order on the motion, defendant filed his offers of proof and evidence in support, identifying 4 individuals as potential alternate perpetrators. The state objects to the presentation of the evidence at trial, arguing that it fails to satisfy the standard under state v. Meister. Defendant conceded at oral argument that at this point his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of trial, but requests latitude in cross-examination of the state's witnesses to try to establish additional evidence to satisfy the Meister standard. The court concludes at this time the defendant's alternate perpetrator proffer is inadmissible under Meister as it is irrelevant and or excluded by Rules of Evidence 403. However, this does not foreclose the defendant from cross-examining law enforcement regarding the reasonableness of its investigation as it follows up on plausible leads. Now, I know it comes across as like, oh, I told you so. But remember, this is what I said weeks ago, just this past week. The judge is going to deny this, but it doesn't mean that the defense can't cross-examine on the investigation or lack thereof by the police officers. God, I hate to say it, but I should be a judge. No, never. Next, it goes into this trial. The standard trial courts have broad discretion in the admission of evidence at trial. A trial court acts within its bounds of discretion when it correctly perceives the issue as one of discretion, acted within the outer boundaries of its discretion, acted consistently with the legal standards applicable to the specific choices available to it, and fourth, reaches its decision by the exercise of reason. Analysis. The seminal Idaho case on the admissibility of alternate perpetrator evidence is Meister. Prior to Meister, a defendant wishing to present such evidence at trial had to first present proof of connection with the crime, such a train of facts or circumstances as tend to clearly point to out someone besides the accused as the guilty party. Remote acts, disconnected and outside of the crime itself, cannot be separately proved for such a purpose. Meister clarified that the Idaho Rules of Evidence, rather than the more onerous Larson standard, control alternate perpetrator evidence admissibility. Under these rules, evidence is relevant if it has a tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Idaho Rules of Evidence 403 govern the exclusion of relevant evidence and permits a court to exclude evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Meister further offered the following guidance on applying these rules and determining whether proffered alternative perpetrator evidence is relevant and admissible. If the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial court's discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitations of the provisions of Rule 403. A defendant has no right to present irrelevant evidence, and even if evidence is relevant, it may be excluded in certain cases. The Idaho Rules of Evidence effectively safeguards against the admission of conjectural inferences without the lower courts needing to apply the Larson direct connection doctrine. Here, the evidence the defendant has offered purporting to establish the four individuals as alternate perpetrators abjectly fails to meet the Meister standard. Namely, the evidence is entirely irrelevant. Nothing links these individuals to the homicides or otherwise gives rise to a reasonable inference that they committed the crime. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. Three of these individuals were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide. Now, let's go to the footnote here. To protect a defendant's constitutional right to a fair trial and presentation of evidence under the 14th Amendment, Chambers actually held that it's actually accused of due process right for the admission of exculpatory hearsay, a confession by a third party, accompanied by the pervasive assurances of trustworthiness. So three of the individuals were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide, lived within walking distance of the crime scene, and were familiar with the layout of the victim's home from prior social events. While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others in the victim's social circles, there is no compelling evidence that any of them had a motive to kill the victims, much less physically harm them or a means to do so. Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. The fourth individual did not know the victims, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicide. He followed her briefly out the exit of the store while considering approaching her to talk. He turned away before even speaking to her. The event was captured on her surveillance camera. This individual subsequently cooperated with law enforcement, provided his phone number and a DNA sample. As with the other alleged alternative perpetrators, lab reports excluded his DNA from the sample taken from the crime scene, and there is no evidence connecting him to the crime scene. Collectively, defendants' proffer with regard to these four individuals fails to give rise to even an inference that they committed the crimes or otherwise make it more or less likely that the defendant was the perpetrator. Therefore, it is irrelevant under 401. Defendant has provided no probative, admissible, significant evidence of motive, ill feeling, means, presence at the scene of any other connection to the crime that could possibly move the ball to the extent it supports an alternate perpetrator theory. At best, defendant's offer of proof can give rise to only wild speculation that it is possible any one of these four individuals could have committed the crimes, which is inadequate under Meister. Again, mere inferences that other people could have committed the crime will most likely not be relevant. In other words, it is not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all the defendants have done here. Even if there was a shred of probative value in the proffered evidence beyond wild speculation, it is excluded under Rule 403. As the 10th Circuit noted regarding the alternate perpetrator evidence, it is not sufficient for a defendant merely to offer up an unsupported speculation that another person may have done the crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion or prejudice. Likewise here, presentation of the proffered alternate perpetrator evidence would pose a great threat of confusing the issue because it would force the state to defend against nebulous allegations that perhaps these individuals were involved. This foray would lead the jury astray, turning its focus away from whether the defendant, only person whose actions are on trial, committed the charged crime. It also presents a threat of unfair prejudice as it would invite the jury to blame unrepresented persons for a heinous crime when there is not a scintilla of competent evidence connecting them to the crime. Finally, it would do nothing more than waste the precious time of the jury and the court in what is already a scheduled 3-month trial. Nonetheless, the court's ruling does not preclude the defendant from confronting and cross-examining the state law enforcement witnesses regarding the thoroughness of their investigation, particularly in following up on and ruling out leads generally. Indeed, the Idaho Court of Appeals recently found in an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to alternate perpetrator analysis. Quote, "We agree with Emerson that a relevant line of inquiry would be to question the scope and breadth of the investigation and to explore on cross-examination whether plausible investigative leads about third parties were ignored or overlooked." End quote. It further stated that this line of questioning may not include inquiries about the investigation of specific third parties absent satisfying the Meister test, noting, while evidence challenging the thoroughness and reliability of the investigation might be probative, questioning whether law enforcement investigated specific individuals with no connection to the murder provided no probative evidence. Moreover, with no connection between the evidence and the crime, there is no explanation or justification for the questioning, and it would not help the jury answer the only question in this case, whether Emerson killed James. The court will apply these same parameters at trial regarding defendant's cross-examination of law enforcement. He may inquire as to the reasonableness of the investigation, including investigating and ruling out other leads. He is not, however, permitted to question law enforcement about the investigation to any specific individual as a potential alternate perpetrator without first raising the matter with the court outside the presence of the jury. Based on the foregoing, the defendant offer of proof of alternate perpetrator is denied. Called it. Hate to say it. Don't want to sound like a know-it-all. Called it. And do you see the alternate perpetrator theory? It shouldn't ever really come in most cases. I mean, I can think of some recent cases where kind of this alternate perpetrator theory, well, it was excluded kind of on the second trial, not so much on the first, but it just confuses everything. The question at a jury trial is, did this person do it? That's it. Did this person do it? Did they commit the act for which they are charged? And to say, well, Jim Bob could have done the crime. You know, he got a little nervous, wanted maybe going to ask one of the victims out on a date, but then he got cold feet. Ha ha, he's obviously the killer. Not relevant. And the defense, even if they got to ask those specific questions, they would be shut down and look like fools. I told you, I think it was even this week, we said that it's probably going to be denied, but the defense is always entitled to question the thoroughness of the investigation, right? Oh, there's a glove out here. You didn't test that. Oh, you did this other blood spot here. Who does that belong to? Oh, you don't know? Oh, you don't know, right? Those type of questions. Just something to think about, ladies and gentlemen. You want complete speculation? You want to go way off on tangents? Feel free to do so. You want to talk serious about the law and the facts? Hopefully that's why you come here. Like I said, I'm sure I could get a lot more views by going off on a bunch of tangents and just pure speculation, but I'm not going to do that. I mean, I can't. I mean, I've thought about it. God, I could go on this particular way. I could get more views. But no, I'm just not going to do that. I'd like to think I have a little more integrity than that. Don't get me wrong. We want to have a successful channel, want to have successful video, but you know, I'm not going to sacrifice, my reputation as a lawyer on just some ridiculous theory that can't prove. Like I said, it doesn't matter what you think. It doesn't matter what you believe in the court of law, ladies and gentlemen. It only matters what you can prove with legal and competent evidence. Now, the defense's job is to raise reasonable doubt. I get it. That's what I do. But you still got to be able to look those jurors in the eye at the end of the day, because you can tell when they're not buying what you're selling. You got to be reasonable. Most juries are thoughtful. They know this stuff is serious. It affects people's liberty, their freedom. They're going to try to do it correctly. But to just go out there and be able to say, we want to throw out these people. They talked to her. They were college kids that talked to a pretty girl. They're a murderer. No, you can't do that. All right, let's talk about the redacted memorandum decision and order on the defendant's motion to continue. All right, introduction. Before the court is the defendant's motion to continue the trial in this matter. The basis for the motion is threefold. First, he asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review all of it. Second, he asserts there is a penalty phase investigation and preparation that still needs to be done. Third, he asserts that the recent and forthcoming publicity on the case is highly prejudicial. Maintaining the current trial setting under these circumstances, he argues, will render any conviction and sentence unconstitutional. The state responds that the defense motion is untimely as he has failed to show either good cause for continuing the trial or prejudice that would result from maintaining the current trial setting. Oral arguments was held on this motion on June 18th, after which the court took the matter under advisement. The court finds a continuance is not warranted as defendant has not made a showing that there is good cause to continue the trial or that his substantial rights will be prejudiced. Now, I'm not going to go through the standards because it's the same one. It's within the court's discretion. Analysis, though, under Idaho law, a criminal defendant seeking a continuance of trial must demonstrate that his or her substantial rights will be prejudiced absent a continuance. Trial judges necessarily require a great deal of latitude in scheduling trials. The burden on assembling the witnesses, lawyers, and jurors at the place and time for trial counsels against continuance except for compelling reasons. There are no mechanical tests for deciding whether a denial of continuance is so arbitrary as to violate due process. The answer must be found in the circumstances present in every case, particularly in the reason presented to the trial judge at the time the request is denied. Where a continuance is sought based upon the late discovery or discovery of evidence, the alleged tardiness of the discovery must be shown so prejudice the defendant's case, preparation that a fair trial will be denied. The bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice so as to support a motion for a continuance. Additionally, where a continuance is sought for the potential receipt of evidence from further investigation, the motion is properly denied if based on speculation. Now, the defendant argues a continuance is necessary for him to sufficiently review relevant discovery, conduct a full and complete investigation of mitigating evidence, particularly claimed newly revealed evidence that allegedly raises, quote, red flags, end quote, and remedy the prejudice caused by recent and upcoming inflammatory publicity and the alleged leak of information to the media. Moving forward with the trial, he warns, will violate his rights under the United States and Idaho constitutions to due process, to be free from cruel and unusual punishment, to a fair trial, to effective assistance of counsel, to present a defense and confront witnesses, and to a fair and reliable sentencing determination. Absent the defendant's materials, however, is any good cause for the continuance or legitimate showing of prejudice should the trial proceed as scheduled. Defendant first contends that the vast majority of discovery in this case renders it impossible for the defense team to review the necessary and relevant discovery in a manner that allows for it to comprehensively integrate it into his defense. He further argues, without any support or explanation, that there is a myriad of issues that continue to arise from the state's failing to comply with the discovery and expert disclosure deadlines. A continuance, he argues, is necessary for counsel to mount an effective defense. The court, however, rejected this same argument 2 months ago when the defendant sought to strike the death penalty and impose discovery obligations upon the state. In its order, the court observed that utter lack of any proof supporting defendant's accusation of discovery violations by the state. More importantly, the court found defendant's complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence, counsel has been unable to review over the past 2+ years, and why efforts to facilitate discovery review were not made long ago through the court and or the judicial judge. Defendant's second round of arguments fares no better. He again fails to identify any relevant discovery that his counsel has yet to review. He also fails to identify any steps his counsel has taken, particularly since the court's prior order, to aid in processing the yet unreviewed discovery. Moreover, he does not explain why he waited to seek a continuance until after discovery closed, expert disclosure deadlines passed, and the pretrial conference occurred. If defense counsel was truly struggling with discovery review, this motion should have been made when the claimed problem became apparent, and certainly should have been brought prior to the expiration of the discovery, all expert deadlines, and the final pretrial conference. Instead, defense counsel has robustly litigated this case, retaining approximately 24 experts and a full mitigation team, engaging in extensive motions practice, and disclosing witnesses and exhibit lists with nary a whisper that a continuance would be sought. These actions belie his counsel's ongoing and ultimately empty discovery complaints. Without more, the court can only conclude that the defense counsel is using this volume of discovery measured in terabytes as a tactics to delay the proceedings at the 11th hour simply for the sake of delay rather than a legitimate threat of prejudice to defendant's substantial rights. Ouch. Calling out the defense attorneys. Ouch. Perhaps even more problematic and more telling is the utter failure of defense counsel now or at any time to specify not only what needs to be reviewed, but importantly, when that review would be complete and the defendant's ready for trial. Instead, the defendant seeks an unbounded continuance with no apparent plan to complete the review of unspecified evidence that counsel claims has yet to review. This is not sufficient to warrant a continuance. Now, there's some redactions up here, so hopefully it'll all still make sense. Defendant next argues he needs additional times to investigate and prepare mitigation evidence, which he contends is necessary to uphold his constitutional rights, particularly under the 8th and 6th Amendment. Specifically, the defense team claims that to be effective, counsel must conduct an exhaustive and comprehensive dive into defendant's life history for additional mitigating evidence, analyze the information into a cohesive narrative for the jury, and identify any additional behavioral, cultural, scientific, and/or mental health experts that may be necessary to develop the mitigation presentation. Despite having hired a mitigation team 2 years ago, the defense counsel contends that recently discovered blank has raised red flags the defendant may have blank. According to the defendant's primary mitigation investigator, attorney blank, her team of 4 have been diligent in their investigation into the defendant's life history, but there have been blank. She believes that with time, she will be able to overcome these barriers by blank. Defendant has not demonstrated a continuance to accommodate further investigation is constitutionally required. The 8th Amendment requires that a capital defendant be allowed to present all relevant evidence in mitigation. In addition, a capital defendant has a 6th Amendment right to fair trial and effective assistance of counsel if both the guilty and the penalty phase of the capital case. As defendant points out, defense counsel is constitutionally required to conduct a thorough investigation in preparation for the penalty phase of the capital case. Presentation of some mitigating evidence, even if strong, is insufficient in other mitigation evidence is available upon reasonable investigation. The assertion that counsel needs the continuance to conduct an exhaustive and comprehensive dive into the defendant's life history for additional mitigation evidence overstates the extent of his counsel's constitutional obligations. Counsel's investigation into mitigation evidence must be reasonable. The Idaho Supreme Court and the United States Supreme Court hold that defense counsel is not required to investigate a defendant's entire life in order to present constitutionally sufficient mitigation evidence. Then they cite to the United States Supreme Court Wiggins v. Smith. We emphasize that Strickland does not require counsel to investigate every conceivable line of mitigation evidence, no matter how unlikely the effort would be to assist the defendant at sentencing. And while defendant notes that the ABA guidelines for mitigation function of a defense team is death penalty cases, urged counsel in death penalty cases to conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character, history, records, and any circumstances of the offense. To meet their constitutional obligation, courts look to what is prudent or appropriate, but only what is constitutionally compelled. Roe, a capital case, is instructive here. On post-conviction, Roe argued her counsel was deficient because they failed to perform an adequate investigation into Roe's background in search of mitigation evidence. Specifically, Roe argued counsel should have investigated her life from birth to sentencing hearing, that counsel were deficient in presenting her mental health workup. The court rejected this claim, holding that counsel was not required to investigate Roe's entire life in order to objectively and reasonably prevent Roe's mitigation evidence. The court further notes that the great lengths counsel underwent to investigate and present mitigation evidence for several of Roe's friends, health and welfare records, letters from friends and family, and Veterans Administration records concerning Roe's husband's previous injuries and the couple's relationship. The investigation defendant's experts have undergone over the past 2+ years far exceed that in Roe, and in fact, readily appear to satisfy the relevant ABA guidelines cited by the defendant. It includes, but is not limited to, defendant's PhD education records, including coursework, interviews, and correspondence. Defendant's mental health and medical records, including blank, records related to a childhood car accident, defendant's employment records, mental health, education, and employment records of defendant's sisters, mental health records of defendant's parents, father's military records and social security records, court records from multiple generations of Kohberger's family on the paternal side, VA records and death certificates from maternal and paternal uncles, multiple interviews with the defendant and each immediate family member, interview of 2 of defendant's 4th grade teachers, former boxing coach, and a psychologist who evaluated defendant in 2005. Interviews with multiple members of defendant's extended family on maternal and paternal side, interview with defendant's professor and advisor at DeSalle University, interviews of defendant's former co-workers, interviews of at least one family friend, and letters and jail calls between defendant and his family. It is evident from the report of the defendant's mitigation expert, Dr. Orr, Dr. Ryan, and Dr. Brams, that they have developed an expansive understanding of the defendant's family, environment, social developmental history, both nuclear and extended over multiple generations, educational history, and mental health and medical history. From this evidence, these experts have rendered several current diagnoses and identified other diagnoses for which defendant met criteria at some point in his life. Despite such an extensive investigation, defendant claims additional investigation is warranted to identify blank and to blank. However, the defendant has not established that such investigation is constitutionally compelled, particularly given the extensive work already completed. Rather, the claim need is based upon unqualified speculation by blank, and defendant has not offered any declaration by any of his disclosed mitigation experts opining the same, nor has he pointed to anything in their expert report that would support blank speculation. As noted, a continuance of trial is not warranted to chase down mere speculation that potential evidence exists. Further, defendant has not set forth a plan for continued investigation, how much time it will take, what the team expects to investigate will reveal, why it is necessary to uphold his constitutional rights, and why these matters are only now being raised with the court. Additionally, assuming guilt is found, the penalty phase of the case will not begin until late October or early November. Thus, there remains significant time for blank and her team to continue their investigation and supplement expert disclosures if warranted. Then it's redacted. Speculation of the defendant, blank, is simply that, speculation built on circumstantial evidence. Then long blanks, conditions which are currently attributed to his own mitigation expert as his ASD, OCD, and or ADHD are consistent with childhood trauma, and there is evidence of poverty, both generational and familial. According to blank, long redaction, notably missing from blank's declaration isn't any indication as to how she intends to confirm her suspicions or how long she expects to take, but that months, years, or even decades. The defendant has been subjected to multiple lengthy interviews by several different experts over the past 2 years. Based on the experts' report reviewed by the court, blank, defendant's family has likewise been extensively interviewed, and there has been no report that blank, none of the defendant's blank has raised the alarm that blank, despite having the same information blank relies upon. Long redaction. Instead, it is an invitation for the perpetual continuance. More importantly, aside from the blank, all the information has been available and documented in the record for months. Yet again, the defendant is only now moving for continuance for further investigation into unsupported suspicion smacks of tactical gamesmanship and delay. Ouch! Absent more compelling evidence that blank, planned for blank, uncovering it at a reasonable timeline to do so, there is no constitutional basis for further investigation, particularly on an open-ended basis with no plan of bringing the matter home. Next session, counsel's argument that more time is needed to investigate whether blank, likewise squarely unsupported, blank. Defendant has never moved for an extension to his disclosure deadlines for penalty phase experts so as to allow further opinions in this regard. Nevertheless, blank, who again is not even marginally qualified to opine, blank, believes that there is evidence that blank and seeks time to unearth it, her support which she has not provided to the court, blank. Again, no one of the defendant's blank experts have had the same information. Blank has submitted a declaration stating that they may change their diagnosis based upon further investigation. Blank. Rather, it is based upon blank speculation that further investigation might change blank. Such speculation is not a ground for continuance. More long blanks. Not only is there a lack of support in the record for blank, anticipation that more investigation into blank to change their minds, and her team and defense counsel may have known since November of 2024 that blank, neither the defense team nor blank have articulated what efforts they have made, if any, since the time to understand the basis. Further, they have not indicated what plan they have to obtain the information if a continuance is granted or how long it will take. Blank. In sum, defendant has not demonstrated that continuance for further investigation into potential mitigation evidence is necessary to uphold his constitutional rights. The right to present mitigation evidence and the right to effective assistance of counsel do not necessitate an investigation of his entire history. They simply require that the investigation be reasonable. While easily available mitigation evidence cannot be ignored, defendant's briefing demonstrates that the evidence they are attempting to obtain is far from easily available and, in fact, may not even exist. Further, the evidence prompted that the need for further investigation has blank been available for months, yet it is only now the defendant seeks a continuance. This tactic seems geared toward achieving delay rather than a good-faith effort to obtain meaningful mitigation evidence. Moreover, the defendant provides no plan for how further investigation will proceed, who will be interviewed, or how long it will take. The Constitution does not demand that this court is not willing to continue the trial indefinitely to allow the defense team to embark on a fishing expedition, pulling at every conceivable thread in defendant's familial tapestry. Counsel's assertion that they will be better prepared with more time and more evidence is an assertion shared by every lawyer involved in a trial. At some point, and particularly after 2.5 years of investigation, the defense team must be satisfied with what they have, which is in this case is extensive. In addition, while the crime victim's rights to a timely disposition under Article 1, Section 22 of the Idaho Constitution and Idaho Code Section 195306 do not trump defendant's federal constitutional right, they provide additional justification for proceeding with a trial as scheduled. For these reasons, a continuance is not warranted. A continuance is not warranted due to pretrial publicity, because the defendant seeks a continuance due to recent inflammatory pretrial publicity. On May 9th, approximately 3 months before the trial is set, Dateline NBC aired a 2-hour episode about this case. The episode included details and materials about this case, which, if true, are not publicly available, and which promote a narrative of guilt. The defendant also advises that on July 9th of 2025, Amazon Prime Video is planning to release a 4-part docuseries about the homicides, and on July 14th, crime author James Patterson is set to release a book he wrote about the same. The defendant contends that the media coverage so close to the trial threatens his right to a fair trial by an impartial jury, which can only be ameliorated by a continuance. In addition, defendant argues that a continuance is necessary to investigate the source of the leaks to the media and impose accountability. The court does not agree that either argument compels a continuance. The Sixth Amendment to the United States Constitution affords all criminal defendants the fundamental right to a fair trial. This includes the right to have an impartial jurors who know as little as possible of the case, decide the defendant's guilt based upon material admitted into evidence before them in a court proceeding, uninfluenced by extrajudicial statements. Trial judge has an affirmative duty to minimize the effects of pretrial publicity. And they cite to the 1966 Supreme Court case of Shepard v. Maxwell. In Shepard, relied upon by the defendant, the United States Supreme Court recognized the adverse effect inflammatory publicity has on the ability to obtain an impartial jury and strongly urged trial courts to act quickly and forcefully in addressing such publicity. The court further advised that where there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial, the judge should continue the case until that threat abates or transfer it to another county not so permeated with publicity. The statement from Shepard, however, must be read in context. The media coverage in that case is far different than what is present here. In Shepard, news reports extensively covered the story of Sam Shepard, who was accused of bludgeoning his pregnant wife to death. The court examined the extensive media fanfare surrounding the case, noting Shepard was not granted a change of venue to a locale away from where the publicity originated, nor was his jury sequestered. For months, the publicity about Shepard and the murder had made the case notorious. Charges and countercharges were aired in the news media besides those for which Shepard was called for trial. In addition, only 3 months before trial, Shepard was examined for more than 5 hours without counsel during a 3-day inquest, which ended in a public brawl. The inquest was televised live from a high school gymnasium, seating hundreds of people. Furthermore, the trial began 2 weeks before a hotly contested election. Both Chief Prosecutor Mann and Judge Blythen where candidates were for judgeships. The court found that there was no doubt that this deluge of publicity reached at least some of the jury, given that when the jury was questioned for the only time, 2 jurors admitted in open court to hearing the highly inflammatory charge that a prison inmate claimed Shepard was the father of an illegitimate child. Nevertheless, the trial judge rejected requests by the defense counsel for jurors to be asked whether they had read or heard specific prejudicial comments about the case. Further, the jurors were subjected to newspaper, radio, and television coverage of the trial while not taking part in the proceedings, and were allowed to go their separate ways outside of the courtroom without adequate directions not to read or listen to anything concerning the case. The judge gave suggestions and requests to the jurors at intervals during the trial to refrain from commenting upon the case, but the jurors were thrust into the role of celebrities by the judge's failure to insulate them from reporters and photographs. Bedlam reigned at the courthouse during the trial, and the newsmen took over practically the entire courtroom. The court reversed Shepard's murder conviction. Crucially, the court stated that although the pretrial publicity alone was not sufficient to warrant relief, when combined with the carnival atmosphere the press created at trial and the judge's inability or lack of desire to control courtroom proceedings, Shepard's right to a fair trial was denied. If months of pretrial media coverage was not enough to deny a due process in Shepard, it is certainly not enough in this case where the media coverage has been far less pervasive. In addition, this court is employing the measures recommended in Shepard to protect the defendant from prejudicial pretrial publicity, to wit, 1, limiting the number of reporters in the courtroom during the trial. 2, insulating prospective witnesses from interviews with the media about their prospective testimony. And 3, making an effort to control the release of leads, information, and gossip to the press by police officers, witnesses, and counsel on both sides to avoid the disclosure of inaccurate and or inadmissible information. Ultimately, whether the defendant can receive a fair trial depends on whether a fair and impartial jury can be seated. As the United States Supreme Court has said, to hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be established an impossible standard. It is sufficient that the jury can lay aside his impressions or opinions and render a verdict based upon the evidence presented in court. Accordingly, the Idaho Supreme Court has long recognized that trial courts can successfully select an impartial jury despite widespread publicity. In State v. Federally, a capital case, the Idaho Supreme Court disagreed with the defendant's claim that the extensive publicity prior to trial deprived him of the opportunity to be tried before an impartial jury. Because each juror was extensively questioned to determine the degree of the exposure to the pretrial publicity, the court found the defendant's rights were preserved. In the defendant's subsequent habeas case, the Ninth Circuit examined at length the entire voir dire process and found no prejudice, even though on the day of jury selection, the case was covered on the front page of the local newspaper, as well as TV and the radio. With the measures the court has already put in place to protect the defendant against the pretrial media coverage and the court's carefully crafted jury selection process, there is no reason to think that an impartial jury cannot be selected through a searching and a robust voir dire. In addition, while continuance may be appropriate if pretrial scrutiny is reasonably expected to fade with time, it is an ineffective tool where publicity is such that there is no reason to anticipate that it would subside by any delay, which would not put off the trial indefinitely. In United States v. Moreno, the Court of Appeals noted the denial of a motion for an indefinite or substantial continuance predicated upon widespread adverse pretrial publicity about a defendant in all the more warranted when, as here, she is sound reason to believe that the defendant will continue to be a controversial, publicly invoked figure, and hence there is little assurance that the passage of time will result in an abatement of subsistence of critical publicity in the foreseeable future. The court observed that the Sixth Amendment guarantee of a speedy trial is one which the government and society, as well as the accused, has a claim, and stated that society cannot be utterly deprived of the right to prosecute and try someone for a crime within a reasonable time merely because of widespread community knowledge. Here, there's no assurance that the pretrial publicity will fade with time. The murders occurred over 2.5 years ago. The circumstances of the murders were provocative. 4 college students in a small Idaho college town were brutally stabbed to death by an unknown perpetrator. It was an immediate media sensation and garnered widespread attention that not only continues to persist, but continues to grow. 18 months ago, defendant moved for a change of venue from Latah County due to, in part, the extensive inflammatory pretrial publicity and allegations made about Mr. Kohberger to the public by media that would be inadmissible at trial. He argued that Latah County was not large enough to avoid the bias caused by the pervasive prejudicial publicity. Defendant's motion was granted, and as a result, the trial date was continued by approximately 10 weeks. Those additional 10 weeks have not resulted in fading media attention. It has only given the media more time and opportunity to provide coverage to a public audience, which is clamoring for answers. The longer the public is made to sit and wait for the facts to come out at trial, the more time there is inflammatory, speculative stories, movies, and books to circulate, and more time for prior ones to be rebroadcast, purchased, viewed, and consumed by the public. Proceeding with trial as scheduled will likely avoid negative consequences for future publicity. Thus, the court finds that a continuance is not warranted. Rather, careful and patient voir dire is prescribed. A continuance is not warranted to investigate the leak. Defendant also asserts that the continuance is necessary to accommodate the special prosecutor's investigation into the source of the leaks to the media and to impose accountability. With regard to the Dateline episode, defendant points out that the Dateline represented that the material came from sources close to the investigation. He notes that Patterson's upcoming book on the crime promises claims to be the most comprehensive narrative of the investigation and evidence to date, and is based upon over 300 interviews. Several individuals include the victim's family and local law enforcement. He also noted that Amazon Prime's docuseries promises to be told in a captivating, tense, and emotionally wrenching detail by only those individuals in and affected by the crime. He argues that if any of the leaks came from witnesses the state intends to call or from those others involved in the investigation, the information is Brady material. It should be served to impeach the leaker's credibility and may be exculpatory in nature. He adds that the investigation reveals that other states had information about the leaks but failed to disclose it. This omission would constitute a Brady violation. As noted, a continuance is not warranted where the information sought thereby is mere speculation. The defendant's Brady argument is built on a house of speculative assumptions, an assumption that was a leak by a person bound by the non-dissemination order, an assumption the leakers will be found, the assumption that leakers will be law enforcement, an assumption that the leakers or others who may be complicit will testify as a government witness, and an assumption that these witnesses will likely be material. Such assumptions are not grounds for continuance, particularly given there is no guarantee if and when they will be confirmed or debunked. The trial cannot be held hostage indefinitely to the outcome of the investigation, particularly given the significant chance the leaker may never be discovered. Thus, the court will not continue the trial pending the results or the investigation based upon speculation, and that will be successful, and the hope the impeachment evidence may be uncovered. If I was defense counsel on that and I read those orders, I'd say, hey, I was doing my job, Judge. But the judge took a couple of personal shots, basically saying, you house of cards, not a scintilla of evidence, basically saying your arguments are all wrong. I'd be like, oh man, I must be a terrible attorney. They're not. They're doing what they need to do. The defense knows the time is to go try this case. And sometimes when you got bad facts against you, you don't want to go try the case, but eventually you have to go find the case. I remember a great attorney once said, at a certain point, you need to stop looking for the document. You need to stop looking for the witness. You need to go try the case. And that's what this case needs to do. The judge did issue one more order. It's an amended scheduling order. The court's prior schedule order is amended as follows. Sealed proceedings with the court and counsel will take place on July 28th through August 1st, more than likely in counsel in chambers of voir dire of potential jurors. Jury voir dire will commence on August 4th, 2025, rather than July 30th, and they continue until a jury is seated. It is estimated the trial itself, beginning with opening statements, will commence on August 18th, 2025. So put that on your calendars, ladies and gentlemen. We will, and we will bring it to you live. All right. So hopefully you listen to those orders. I think is relevant. I think a couple of things obviously jump out that, there's a special prosecutor. Obviously, they knew they were going to investigate it, but Sounds like a special prosecutor has been appointed to look into those leaks. Tough day for the defense. Tough day for the defense. Next on the docket, though, things getting better for Sean Combs. In the closing arguments of Sean Combs' sex trafficking trial, the defense attorney presented a series of arguments to counter the prosecutor's allegations of sex trafficking, racketeering, and transportation to engage in prostitution. Let's give you a summary of the defense key points. Here we go. So during the closing arguments, the defense counsel argued for Sean Combs, sought to reframe the prosecution's narrative by emphasizing the consensual nature of the defendant's relationships and the challenging the characterizations of his actions as criminal. The defense's primary arguments are as follows. First, consensual relationships. The defense argued that the relationships between Combs and his former partner, Cassandra Ventura, was rooted in mutual affection and voluntary participation. He described their decade-long relationship as profound emotional connection, asserting that Ventura remained with Combs out of love, not coercion. The defense highlighted text messages exchanged between Combs and Ventura, which the attorney claimed demonstrate genuine affection and would evoke empathy from jurors upon review. This portrayal aimed to refute allegations that Ventura was manipulated or forced into sexual activities, including these so-called freak-off events. And the defense, they acknowledged there was some domestic violence, but that's not sex trafficking. So addressing the wildly publicized 2016 surveillance video depicting Combs physically assaulting Ventura at that Los Angeles hotel, the attorneys conceded that the footage constituted domestic violence and was deeply regrettable. However, he maintained that this incident did not substantiate the prosecution's sex trafficking charge. The defense argued that the altercation was an isolated matter of personal misconduct, resolved privately between Combs and Ventura, and not indicative of a broader criminal scheme involving coerced sexual exploitation. And you see what he did there, ladies and gentlemen? Sometimes attorneys refuse to acknowledge anything. One could say that there was no beating in that hallway. I didn't see anything. It looks like foreplay. I don't know what it was, but it wasn't a beating. Some attorneys would get up there and argue that. Some people would say that was completely fine. You have to have credibility in front of a jury of reasonable people. They're going to say, your client was beating up that woman. Yeah, it was. But guess what? It's not sex trafficking. Sometimes you have to concede a point, right? They teach you that when you go to learn to debate. Sometimes you have to concede points. Some people never concede anything these days. Very frustrating. Anyway, his attorneys acknowledged that Combs' struggle with substance abuse, admitted that the defendant had a significant drug problem. However, he clarified that Combs' drug use was personal and facilitated through intermediaries due to his public profile, not indicative of drug trafficking or distribution. And the defense emphasized that the prosecution's attempt to link Combs' drug use to racketeering was an overreach, asserting that personal substance abuse does not equate to organized criminal activity. The defense challenged the prosecution's reliance on physical evidence such as baby oil and personal lubricants seized during the 2024 raid of Combs' Los Angeles residence. The defense argued that these items were misrepresented as evidence of criminal activity when they were in fact related to private consensual behavior. He continued to contend that the prosecution's focus on such items was an attempt to sensationalize Combs' personal life rather than to substantiate serious charges like racketeering or sex trafficking. The attorney underscored Combs' positive attributes, portraying him as a generous individual who supported those around him, including paying significant rent to former associates. The defense argued that such actions reflected Combs' character as a caretaker, not a manipulator engaged in racketeering. Additionally, they argued that Combs' early adoption of diversity, equity, inclusion principles in his business, presenting him as a socially responsible entrepreneur since the early 90s. The defense noted the presence of Combs' family, including his mother and children in trial, suggesting their attendance as evidence of personal integrity and familial bonds. They argued that Combs' commitment to his family and community contradicted the prosecution's depiction of him as a criminal mastermind. But guess what? The judge did admonish the defense because they were allegedly improperly suggesting that jurors could consider the motive behind the prosecution's decision to bring the charges. The judge deemed this line of argument grossly improper and instructed jurors to disregard it, reinforcing that such considerations were irrelevant to their deliberations. The admonishment underscores, obviously, the defense challenges in navigating the boundaries of permissible legal argument. I say push them till they object. and then keep going until it's sustained. The jury will probably start deliberating Monday because the prosecution gets their second rebuttal after the defense gave theirs. So there you go. Will Sean Combs walk? He may. I mean, he could go down on, something, but racketeering, I don't know. Seems a little tough. We'll have to wait and see. I don't know. I wish I had a better answer for you. I wish I could pick up the magic 8-ball and say, will Sean Combs be convicted? Magic 8-ball says, my sources say no. That's as good as we can get it to you today, ladies and gentlemen. I don't know. We'll have to wait and see. Next on the docket, a man accused of attacking his landlord on Tuesday night in Jensen Beach, Florida, has been arrested. That's right. Let's jump off to Florida for a little landlord dispute. Please meet Bryan Leach. The guy's 69 years old. He was released from the hospital on Thursday and taken into custody by the Martin County Sheriff's Office. He's being charged with attempted murder after investigators say he lured his landlord downstairs into the home where he attacked her. Now, Leach reportedly rents the lower level of the two-story home, and the landlord lives on the top floor. After attacking her, Leach then got into his car and then rammed it into the home, causing structural damage to the house. The landlord is still recovering from her injuries, and investigators said that they believe that Leach flew into a rage after the landlord mentioned possible eviction. Well, Mr. Leach has been booked into the Martin County Jail. Good luck on that. And next, the Florida teacher's alleged classroom misconduct reaches some new lows. In a shocking display of professional decorum, Sarah Jacobs, a 32-year-old teacher at the Corner Lake Middle School, has been arrested for allegedly turning her classroom into a stage for reprehensible behavior with a 14-year-old student. Now, the Orange County Sheriff's Office, clearly thrilled to handle such matters, charged Jacobs on June 23rd with lewd and lascivious battery, molestation, and statutory rape by an authority figure. Now, one can only imagine the pride she must feel for such a distinguished rap sheet. According to the arrest warrant, the alleged victim, now 16, recounted to deputies on June 10th how Jacobs, in a heartwarming effort to help him fit in, invited him to eat lunch in her classroom during the 2022 and 2023 school years. And what began as a notable gesture of mentorship allegedly spiraled into a masterclass in isolation as Jacobs temporarily distanced the boy from his peers. Hugs and cheek kisses, how quaint, soon escalated, per the affidavit, into molestation, truly a model of educational guidance. Not content with mere face-to-face impropriety, Jacobs allegedly crafted a fake Instagram account to exchange messages with the boy because nothing says responsible adult like late-night dirty talk with a minor. The affidavit claims that she once mused, "I just had sex with my husband, and it wasn't the best, but I imagine it was you." Charming. The boy's mother, displaying a rare moment of parental vigilance, caught them texting at 1 a.m. and demanded it stop. Jacobs, ever the innovator, simply switched to her covert social media account. The piece de resistance allegedly occurred a week before spring break in 2023, when Jacobs, with the foresight to cover her classroom windows with activities assailant curtains, reportedly laid a pillow in the corner and engaged in unprotected sexual intercourse with the boy. One can applaud her commitment to creating a cozy ambiance for such an occasion. The routine allegedly continued daily until the break, when Jacobs' husband, presumably less than delighted, discovered her antics. Posing as his wife on her secret account, he contacted the teen, and Jacobs later warned the boy to lay low because her husband was understandably displeased. Jacobs vanished from school for the remainder of the year, perhaps to reflect upon her pedagogical contributions. And then on June 16th, the alleged victim, with law enforcement listening, called her. Through the affidavit, coyly redacts the details. Jacobs was booked into the custody on June 23rd, making her first court appearance the next day, and was released on bail by June 25th. Her public defender, likely thrilled with the case, has not yet commented, and the school principal, in a display of administrative efficiency, informed families of an ongoing investigation and assured them Jacobs would not return pending its outcome. What can you say, ladies and gentlemen? I don't know what to tell you. They just keep coming. They just keep coming. Every day, another female teacher. We expected all the male teachers, but what's up with all the female teachers? My God, unbelievable. You're a professional. You shouldn't have a relationship with a student. pretty clear. Pretty clear. If you're in college, you shouldn't have a relationship with your student in college. Inappropriate. Relationship somebody you work with. Inappropriate. Don't do it. And particularly don't do it when they're under the age of 18, for God's sakes. My God. We're going to have to break out the Crime Talk rules of dating here soon, just as a refresher for the teachers before they come back after the summer break. Right? Don't do it. Next, let's be a little more serious. Not that sexual assault on children is not serious, but let's talk about the United States Supreme Court. So the 2024-2025 term of the United States Supreme Court, which began on October 7th of last year, concluded in late June, featuring several significant decisions addressing issues ranging from gun regulation, transgender rights, to environmental policy and free speech. Let me give you a quick summary of the major decisions based upon, what we know so far. All right. First, so the major decisions: ghost gun regulations, United States v. Vanderstock. Whether the Bureau of Alcohol, Tobacco, Firearms, and Explosives would regulate ghost guns, unserialized firearms assembled from kits. In a 7-2 majority, upheld the 2022 Biden administration regulation requiring background checks, serial numbers, and sales records for ghost guns. Justice Sotomayor, Jackson, Kagan, Roberts, Kavanaugh, Barrett, and Gorsuch formed the majority, with Alito and Thomas dissenting. Obviously, the decision strengthens law enforcement's ability to track homemade weapons used in crimes, making a departure from the recent trends of loosening firearms restrictions. Actually, then we had another issue just decided last week, transgender care for minors. Obviously, these are not criminally related issues, but obviously important issues the United States Supreme Court thought that they needed to wade into. The issue whether Tennessee's Senate Bill 1 banning gender-affirming care, i.e. puberty blockers, hormones for transgender minors, violates the Equal Protection Clause of the 14th Amendment. On June 18th, the court, in an opinion by Chief Justice Roberts, affirms the Sixth Circuit ruling, applying the rational review and upholding the law. The court found that the law's classification, age, and medical use did not require the heightened scrutiny for constitutional violations. The decision upheld the state's ban on gender-affirming care for minors, potentially limiting access to treatment nationwide. Then we have the birthright citizenship and the nationwide injunctions. Now, this did not decide the issue of birthright citizenship. This decided basically, why are all these lower district courts thinking that they can put in a national injunction, nationwide injunction? The court slapped them around, kind of like Judge Hippler slapped around Kohberger's attorneys. So the issue was whether lower courts exceeded their authority by issuing nationwide injunctions blocking the president's executive order on birthright citizenship, which sought to exclude children born to non-citizen parents from automatic citizenship. The court limited the ability of lower courts to issue universal injunctions, effectively allowing the executive order to proceed in some jurisdictions. Now, though the constitutionality of the order itself was not directly addressed, it hasn't been decided yet. So the impact of the decision curtails the scope of judicial powers to block executive actions nationwide and has implications for the enforcement of immigration policy, as everything else. I mean, you get these judges, both sides, so let's do it. Both sides go judge shopping. They find a judge, they issue an injunction, they make it nationwide. The court basically said, and I just reviewed the summary from the opinion, it's basically like this. The only branch of the government, as has to do with the courts, is obviously in Article 3 of the United States Constitution. And the only court formed under the Constitution is the United States Supreme Court. All the other courts are created by statute. And so their jurisdiction is thus created by statute. And they can't do things that exceed their statutory construction. And basically what this is saying is none of this existed back in the founding days of the Constitution. And U.S. district courts, lower courts, you have no right to impose these vast injunctions to impose your will, basically, on people that are not before the court, right? You have to have a case in controversy between parties. And you can't say, well, this case or controversy came before me, I'm going to make it apply to everybody. Maybe the other party doesn't want to be involved in it, right? Think about it in the civil context of a class action lawsuit. You can opt in or you can opt out of it, but you got to get a choice. And so the court limited that. Now, one big quote here. This is from Amy Coney Barrett, who wrote the opinion. kind of a slap at her fellow justice. It says, "We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary." Ouch. Little judicial backhanded slap, right? Basically saying, hey, you can't say the judiciary is protecting us from a quote dictator, and then you, as the district court level, are acting as a dictator saying, I don't like this policy, therefore it can't go forward. That's the legislative process. That's voters to decide, not the court to decide whether it's good policy or not, only whether it violates the law. Going to be huge ruling on lots and lots of cases. Next, the question of the Affordable Care Act, whether there were requirements for private insurers to provide preventative care without copays or deductibles. Anyway, it ensures continued access to free preventative health services affecting health care coverages for millions of Americans. Then the religious rights in school, which came out today. Mahmoud v. Taylor. This was whether the Montgomery County, Maryland public schools violated parents' First Amendment religious freedoms rights by not allowing opt-outs of LGBTQ plus minus inclusive curriculum. So the court sided with the parents, ruling that the school must provide an opt-out option for religious families, as exposure to such materials could be coercive. Obviously, it strengthens parental rights to exempt children from specific public school teachings, potentially disrupting classroom instructions if widely adopted. Now, this was interesting, is the school wanted to have these classes. They provided an opt-out provision. Basically, so many of the parents opted out that there weren't any kids to be in the class or seminar, made it basically not worthwhile. So the school said, there's no more opt-out. Everybody. We're talking grade schoolers here, ladies and gentlemen. I remember all that stuff. We didn't have these issues when I went to school, but I remember kids opted out of the sex ed class if they thought it was inappropriate to learn about, things in sex ed class. What were we, junior high, 6th, 7th grade, maybe? I guess 7th, 8th grade, 7th, 8th, 9th, right? You opted out. But everyone else is like, okay, we're just sitting there wide-eyed and bushy. Oh, boy. A lot different these days. Next, Texas age verification law for pornography. Free Speech Coalition v. Paxton. So the issue is whether Texas's House Bill 1181 requiring age verification for websites with over 1/3 sexual material harmful to minors violates the First Amendment's right to free speech. Oral arguments were heard back in January, but a final ruling is not available as of yet. But that's another one that could drop today. But that's going to assess whether the law infringes on adults' free speech or is it permissible restriction to protect minors. I predict it's going to be okay to protect minors based upon the previous ruling as it relates to transgender surgeries. Another big one was San Francisco v. EPA. The court weakened the Clean Water Act by striking down vague EPA permit provisions for pollution discharge, clarifying standards for cities and businesses, but complicating pollution enforcement. The court ruled that fuel producers have standing to sue the EPA over California's electric vehicle mandates, affirming their right to challenge state-specific regulations. Then we have the 7-county infrastructure coalition versus Eagle County, held that the National Environmental Protection Act, NEPA, does not require federal agencies to study environmental impacts beyond their direct regulatory authority. Well, that would make sense, right? You can only investigate what you're given by statute to investigate. Anyway, these limit federal government regulatory powers, favoring business, clarifying potential and undermining climate change mitigation efforts. Then we have TikTok v. United States, which was decided several months ago, whether the law requiring TikTok to divest from Chinese ownership or face a ban violates First Amendment rights. The court upheld the divestiture law, prioritizing national security concerns. Makes sense. Then we have the charter schools, which is the St. Isidore of Sevilla Catholic Virtual School versus Drummond. The issue is whether Oklahoma could use public funds for a religious charter school teaching Catholic doctrine. A 4-4 split, Judge Barrett recused, affirmed the Oklahoma Supreme Court's block on the school, as no majority was reached. So it maintains the status quo, limiting direct public funding for religious schools, but leaving room for future challenges. And then we have Gutierrez v. Sienes. A district court cannot consider retribution factors, i.e. seriousness of an offense, when revoking someone's unsupervised release. And then under the First Step Act, sentencing reduction guidelines do not apply to pre-FSA sentencing, later vacated. And then Medina versus Planned Parenthood came out yesterday regarding South Carolina. The Fifth Circuit's movement, Medina v. Planned Parenthood lacks standing to sue South Carolina over the Medicaid exclusions. And then Barnes v. Felix, the Fifth Circuit's movement of a threat, a rule of police shooting was deemed too narrow and expanded Fourth Amendment protections. All right, so the terms obviously marked by a conservative majority of 6-3, shaped by Trump-appointed justices Gorsuch, Kavanaugh, Barrett, influencing outcomes on issues like gun rights, religious freedoms, and regulatory power. And public approval of the court remains somewhat low, with debates over ethics and reforms ongoing. There's the Supreme Court. I'm a member of the United States Supreme Court. Got to go there, see the arguments, name on the actual brief. It was an amicus brief, but it's a brief. It's the United States Supreme Court. How many attorneys have one of those bad boys? Not many, ladies and gentlemen. Anyway, there's also a bunch of talk about the emergency dockets. The court has handled numerous emergency dockets, particularly those related to executive actions, which has increased the court's workload. But that's going to come to an end because now you're not going to have nationwide injunctions issued by district court judges. So we'll see. A couple of cases still outstanding is the Stanley v. City of Sanford and the voting rights from Louisiana v. Callias were decided, will hopefully be decided sometime today. Next on the docket, this day in legal history, June 27th, 1844. The Mormon leader Joseph Smith and his brother Hiram are murdered by a mob while jailed in a jail in Illinois. June 27th, 1970, Congress passes the Organized Crime Control Act, including the RICO statute, to combat the mafia and racketeering. And Sean Combs. See how they start off one way and then somebody says, sure, this was for the mob and union organizers engaging in basically racketeering type activity. But what about a guy who wants to get his freak off and brings a bunch of drugs and some weird, kinky, weird stuff with consenting adults? Racketeering, maybe? The old camel under the nose argument. That's the old camel under the tent argument. Next, June 27th, 1991, Payne v. Tennessee. Supreme Court rules victims' impact statements are allowed during death penalty sentencing. June 27th, 2025, the court narrows the scope of nationwide injunctions, limiting how federal judges can block laws outside their districts. Why should a judge in California tell court in Colorado or the people in Colorado what they can and can't do? Makes complete sense, but it just shows you everybody loves power, ladies and gentlemen. But let's talk about a little Supreme Court stuff. The authority, our quote of the day. The authority of the Supreme Court of the United States is grounded in the United States Constitution, specifically Article 3, Section 1, which states, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may, from time to time, ordain and establish. There you go. Those courts only exist because Congress allows them. They could get rid of the district courts tomorrow. They're not going to, but they could. They could expand them. They could say, you can only handle these types of cases. Congress could do that. Limit what they have jurisdiction over. Anyway, next, the constitutional provisions established the Supreme Court as the highest judicial authority in the United States with the power to interpret the Constitution and federal laws. A quote from Chief Justice John Marshall in the landmark case Marbury v. Matterson further clarifies the court's authority. It is emphatically the province and duty of the judicial department to say what the law is. Not to say whether it's a good law or bad law, but whether it complies with the Constitution. That case, that quote goes back to 1803 in a case called Cranch. It underscores the Supreme Court's role in exercising judicial review, ensuring that laws and executive actions comply with the Constitution. And finally, our dumb criminal of the day. I know it's been a long show. Thanks for holding on to this, ladies and gentlemen. We had so much information to talk about today. And our dumb criminal of the day goes to, ladies and gentlemen of The Office, gather round for a tale so absurd it could only come from the annals of What Were They Thinking? Our winner, Officer Zamir Vargas Valerio of the City of Miami Police Department, has clinched the coveted title with a stunt that equals part audacious and frankly baffling. Picture this: Zamir, apparently nursing a broken heart, decided the best way to reconnect with his deployed ex-girlfriend was not a heartfelt email or a care package, but a fake ticket. That's right, a fake traffic ticket. Yes, you heard that right. While his former flame was serving overseas, Zamir allegedly hijacked a colleague's computer login, because who needs permission, and issued a citation so bogus it might as well have been written in crayon. The plot thickens when the victim's mom, even the vigilant parent, tipped off her daughter about a mysterious traffic court notice. Our overseas hero, understandably confused, checked with the Miami-Dade clerk of the courts only to learn that the ticket was officially issued. The catch? The officer listed was conveniently on disability leave at the time. Oops. Cue the Miami Police Department's Internal Affairs Division and the Miami-Dade State Attorney Office, who unraveled this caper with the precision of a sitcom takedown. Zamir, now facing 2 third-degree felony charges, official misconduct and offenses against a computer system users, proving that using police resources for petty X games is not just a bad idea, it's a felonious one. Now, the state attorney summed it up best. This is not only beyond normal comprehension, but is also a violation of the law. Translation: is this the kind of move that makes you wonder if Zamir thought internal affairs was just a spicy rom-com? Anyway, the police chief, clearly unimpressed, issued a statement faster than you can say betrayed the badge. He made it crystal clear that the department isn't for Zamir's shenanigans, emphasizing integrity, accountability, and all the things our winner apparently skipped in training. The chief's message: one bad apple won't spoil the bunch, but it sure makes for a juicy story. So let's raise our coffee mugs to Officer Zamir Vargas Valerio, whose spectacularly misguided attempt at romance has earned him a Dumb Criminal of the Day crown. May his story remind us all, if you're going to shoot your shot, maybe don't aim with a police computer. Stay smart, aficionados, unlike our pal Zamir. And remember, the Constitution matters.